Good afternoon, everyone. I'm just going to give it one moment before we get started on the webinar this afternoon. All right. So I know some attendees are still filtering in right now, but because we've got lots of good content to cover this afternoon, I'm going to get started right now. So first of all, welcome to the Disability Management Essentials Hotspots Fall webinar. So as you will all have seen, this is our first of our Fall Hotspots webinar series, the first of 3 different webinars that we're going to be covering this fall. So today, Alex Pressey, who you can also see on the screen, my colleague, and I are going to be talking about a variety of key issues that employers and human resources professionals are dealing with these days related to disability management. The next in the session is going to be on October 17th, where I'll be joined by Faraz Karanji and Ni Huyn, 2 of our lawyers on the team, to discuss terminations and all of the latest developments and hot topics to discuss there. And then the third in the series will be on November 21st. At that point, Alex will be joined by my partner, Laura Williams, and Ingrid Waboa, another one of our lawyers, to discuss workplace investigations. We've called it Hotspots for a reason. Lots of hot topics in all 3 of those to discuss. And so I really hope that you enjoy this first session. We'll be speaking today from 12 until 1:30, and we are going to save some time at the end with respect to questions. So what we would suggest is please put your questions into the Q&A box. Hopefully you can all see that. If anybody has issues, let us know. But generally the questions should be in that Q&A box. And then we may tackle a couple of the questions as we go throughout if they're particularly topical for the content we're discussing at the time, but we do intend to save time at the end to cover the bulk of those questions. And so really our plan today is to provide some of the most important information that you're going to need to know when it comes to disability management and accommodation. These are key concepts with employee human rights, of course, being central to these issues. Now, as a really quick refresher, just to get us started, every province does have its own human rights legislation that's going to govern their provincially regulated employees within that province, provincially regulated being the bulk of the employees in a province. And on the other hand, the Canadian Human Rights Act, that governs federally regulated employees. For employers such as interprovincial transport, telecommunications, and a couple of others. But again, the bulk of you here will likely be governed by your provincial human rights code or act, as the case may be. Now, of course, because there's different legislation across the country, different human rights legislation will have slight differences between them. But there is a lot of overlap across the country in these human rights statutes, and particularly when it comes to the protected ground of disability, there's a lot of consistency. Of course, disability is protected in every single piece of human rights legislation across the country, and so it's something that will be quite comparably dealt with in each province. Where we talk about the Human Rights Code, typically we'll be talking about the Ontario Human Rights Code, as I know many of you are based in Ontario. But again, in most cases, the principles that we're talking about will apply nationwide. Now, of course, accommodation is a very broad topic. There's lots to cover there. And disability management really is an even broader topic than that, with accommodation at its core. Disability is by far the most common protected ground that employers have to deal with. I'm sure all of you here who have dealt with accommodation situations would agree with me there. And it's becoming more and more challenging for employers to deal with. Of course, there are other protected grounds that employers have to contend with accommodating as well. Family status, like childcare responsibilities, is becoming more and more common as an example. But we'll really be focused today on the disability protected ground, although a lot of the concepts we'll talk about will apply in other areas of protected grounds as well, like family status and others. So really day to day, I'm sure many of you would agree, employers are struggling with employees' disabilities, impacting their ability to work and the employer's ability to provide their proper accommodations for those disabilities. I'm so many of you here, and I'm sure all of you here will work very hard to provide that inclusive workplace to your employees so that you're allowing those employees who have disabilities to participate as fully as possible in the work and in the workplace. And taking active steps to be inclusive of course, goes a long way in helping to limit issues related to disability management that you might deal with as an employer. It doesn't, unfortunately, eliminate those challenges that you'll deal with. The reality is that employees' medical limitations, disability limitations, and in other cases, their expectations related to disabilities that they may have, even where those may go beyond their true medical limitations, those will impact employees' ability to work. And in some cases, employers will have challenges in trying to accommodate that and manage the employees' expectations, the requirements of the work. For the HR professionals who are attending here today, I'm sure you'll have experienced this many times. The expectations of managers or their coworkers, they may not be happy that their coworker isn't in their perception pulling their weight when they may not really understand what's going on. And so you need to be really careful in dealing with these things. And of course, there's a lot of risk that can come if disability management is not managed effectively. Now, of course, there's specific aspects of this that are going to be particularly challenging for employers, like mental health disability accommodation, for example, that we'll spend some particular time on today. But we'll really just try to cover, a variety of areas of disability management to give you the tools to go back into your workplaces and make sure that you are managing these things effectively and limiting the number of times that you need to speak to people like Alex and I. So with that, I know I've introduced the two of us, so I won't spend a lot of time here, but as I mentioned, of course, I'm Joel Smith. I'm a partner with the firm, and Alex, as I mentioned, is Aleksandra Pressey. She's another lawyer and investigator with our firm. And again, thank you for taking your afternoon today, or a little bit of your afternoon, to join us and learn about disability management. So I'm going to start off just by taking you through the roadmap. Here's what we're going to be covering this afternoon. First of all, we're going to be discussing the duty to accommodate generally. I want to do a little bit of level setting to ensure that you're all on the same page about what the duty to accommodate broadly includes, what the scope of that duty is. So again, we all are coming at this from the same perspective. From there, I'm going to pass it over to Alex, who's going to take us through some of the really important things to understand around requesting medical information. As you'll hear us say throughout the session here, requesting medical information is such a crucial part of disability management. And so we're going to discuss how and when employers can request and when they should request medical information in order to understand how that can be maintained and used and understood in this process. From there, we're going to, as I mentioned a moment ago, discuss specifically mental health accommodation in order to ensure that you understand that key issue that's becoming more and more challenging for employers to deal with for all sorts of reasons that I'll get into. And then I'm going to pass it back to Alex to talk about disability management in the time of remote work. We're going to talk about how the huge explosion of remote work and hybrid work scenarios has impacted the accommodation process. I'm sure many of you have had that request from employees. Well, I want to work fully remote as an accommodation. I've done it before. I did it during COVID. Why can't I? And that's a common challenge that our clients are continuing to deal with. I'm sure many of you are. So we're going to talk about that. But we also want to talk about some of the advantages that the possibility of remote work that may not have existed a few years ago does create for you and giving you more tools in your arsenal as an employer to accommodate employees. From there, we want to hit on something that is often little known or little discussed, but a really important thing to bear in mind when it comes to disability management. And that's the overlap and the relationship between the human rights accommodation obligations that employers have with workers' compensation, or WSIB, when it relates to employees' workplace injuries, as well as the overlap or relationship between accommodation and disability benefits, like short-term disability benefits and long-term disability benefits. These are areas that do often create issues for organizations to manage. And there's a lot of misconceptions out there about how these processes work and how they overlap with one another. And so we're going to spend some time there really discussing the importance of each of those and the obligations that will continue when you're dealing with multiple of those at the same time. From there, we're going to shift into, of course, a big reason why effectively managing disabilities is so important, and that's that there's liability, there's costs that can come with that. Now, we're not only going to talk about legal liability and the specific financial costs that can come with this, we're also going to discuss the broader business costs that can arise from dealing with disability management. Well, they're going to wrap with the key takeaways at the end of the session, and just really hit back on some of the key points that we want to make sure you take away with you at the end. And then, like I said, we're going to take some time at the end to cover many of the questions that you'll be putting through today. What we'll ask with respect to the questions is that you please do drop them into the Q&A throughout the webinar. There's a lot of content to cover, and I know oftentimes I talk to clients after we've done webinars like this, and they say, "Man, I had this question, this thought that I had, and then I lost it when you went on to that next topic." So so we don't lose it, and so we can make sure that we're responding to those questions. Just drop them into the Q&A, and then we'll come back to them when we have a chance. Okay, so without further ado, I'm going to get us started. So again, I want to just start off with the concept of the duty to accommodate. I'm not going to spend a long time here. So for those of you who may know all about accommodation already, bear with me. I just want to make sure that we're all, on the same level as we get into the content here. So first of all, when does the duty to accommodate arise? Generally, it's going to arise when the worker, the employee, comes forward to their employer, their manager, or to HR, and they say they have an accommodation need or they have medical limitations. And then, of course, that duty to accommodate will be triggered. Now, it's important to acknowledge that while that is typically the way that accommodation is triggered, where that duty is activated, there is also an active duty as employers that you have to inquire. So it's called the duty to inquire that you really need to understand. And so that duty to inquire, that's going to arise where an employer knows or reasonably should know that an employee has a disability that may require accommodation. So that might happen, for example, where an employee is suddenly repeatedly missing work or is saying things that, about a medical condition, making some sort of, allusions to a medical condition that they may have, without specifically saying, "Hey, I need accommodation." In other cases, it's less obvious. The employee's behavior may change, somewhat suddenly or significantly. Sometimes it's an employee who's, consistently, putting out really high quality work, and suddenly that suffers significantly, or they become a lot more sensitive or a lot more easily frustrated with their coworkers when they used to be someone who gets along really well with others. These types of things, these behavior changes, as well, absences and other things, these can trigger that duty to inquire that you need to bear in mind as an employer, because if you don't inquire in those circumstances and then an accommodation is not provided that ultimately the employee really did require, you can face liability as an employer at the end of the day. So with that said, the duty to inquire does arise, and arises fairly often, but a more typical accommodation situation is going to go something like the employee going to their manager and saying they can't perform a certain part of their job, or they need this modification to their hours because of some sort of medical limitation that they may have. And then the next step is the manager will share with HR, or certainly the manager should share with HR. We have lots of situations where, HR professionals that we communicate with didn't hear about the information until some weeks later, and that's often why the lawyers get involved. Is some steps were taken that created some challenges, but certainly the manager should bring it to HR, and then HR should seek information and determine if there's any accommodations that the employee may need, and then they should determine, working with the employee, what accommodations may be needed and implement those. So I'm going to just discuss a brief example of a situation that is not a completely uncommon one. Certainly the specific situation, fortunately, is not something that a lot of us have to deal with day to day, but a situation that these circumstances can arise broadly for employers. And so this was a decision from the Human Rights Tribunal of Ontario earlier this year involving the TTC. So involved a unionized employee who worked for the TTC as a subway vehicle technician. And so this employee ultimately was let go for sleeping on the job. The employee had a medical condition that did impact potential falling asleep while at work, which, as we'll talk about in a moment, was not known to the employer at the outset. The employee did have a record of discipline for sleeping on the job, so there were 2 last chance agreements on file from the couple of years before this situation occurred, where the employee had fallen asleep and then was given a last chance agreement saying, if this happens again, you're going to be let go. Then after the employee was found sleeping a 3rd time, the employer conducted an investigation and then dismissed the employee. And before they fell asleep that 3rd time and this investigation occurred, the employee had never actually informed the employer that they had a medical condition. This was only brought up, after the investigation, after the dismissal, in the context of mediation, mediation of a grievance arbitration that was going on between the union and the employer, the union on the employee's behalf. So in that case, the employee did go and provide medical, and it did support that there was a medical situation going on. And so the employee claimed that they were let go because of their disability, at least in part because of their disability, and that the employer had failed to consider the disability that they have in the context of the dismissal. And so by disciplining rather than accommodating, the employer had failed in their duty to accommodate and ultimately violated the Human Rights Code. That was the allegation. The Human Rights Tribunal did not agree. Fundamentally, it came down in large measure to the employer did not know about this employee's condition until after the dismissal had already occurred. So they dismissed an employee who kept falling asleep at work when obviously it was important, given the role that they did, not to fall asleep at work. I'm sure many of you would probably argue that it's important that all employees don't fall asleep at work. And so, in that case, because the employee had not brought the condition to the employer's attention, and the employer didn't reasonably have, an obligation to inquire into determining whether the employee did have that accommodation need, they couldn't have known, they didn't know, and so the disability could not have played a role in that dismissal. And so there was found to be no discrimination, no human rights violation. The employer did prevail at the end of that hearing. Now, I do want to bear in mind, this is a great outcome in a situation where an employer, had taken the right steps. It's not uncommon that something different could happen, right? If the employee could have convinced the tribunal that they did tell one of their managers about this condition, which the employee in that case did try to argue at the hearing, then it may very well have gone differently, and it may have been that the tribunal may have found this employee was discriminated against. And so again, it's just really goes to show the importance as an employer to, when it's brought to your attention that there may be an accommodation need, take those next steps to deal with it. And so what are those steps that you should be taking to deal with that? The first thing I'm going to really briefly touch on is that there are 2 primary parts to the duty to accommodate. There's the procedural duty to accommodate and the substantive duty to accommodate. And to really simplify, the procedural duty to accommodate is that process that the employer is expected to take part in to communicate with the employee, and if there's a union, to communicate with the union as well, because they're also a party to the process, to look for appropriate accommodations in light of the employee's limitations and needs, and then to have that communication. The substantive duty to accommodate is that actual duty to provide reasonable accommodations to the employee based on that assessment that's done. And so the duty to accommodate is it's this multi-party search between these different parties, and you have to work together to do it. A lot of times, employees may feel that they don't need to work together with the employer. They just say what they need, and that's the end of it. But it really is not that simple. It is a multi-party process, and you have to work together with the employee to determine what accommodations can be provided. And again, it really is a 2-way street. The employee has to play ball. They have to cooperate. They have to work with the employer just as the employer does. So the last part I'm going to talk about before I pass it over to Alex is to really understand and shed some more light on this really important distinction that I'm sure a lot of you have heard before, but I want to just talk about it a little bit to really ensure this is clear for everyone. So this is the distinction between reasonable accommodation, which is the legal obligation that employers have, and perfect accommodation, being something that the employer does not have an obligation to provide, despite, as I mentioned a moment ago, employees may expect that they do. And so it's, a lot of employers, a lot of managers, especially those who haven't dealt with this process before, may believe that, if the doctor says, provide this accommodation, this is what they need, or the employee says, this is an accommodation that I feel I need, they need to provide that accommodation, that's the obligation. And that's not the case. Again, the law requires you to provide reasonable accommodation, but not perfect accommodation. And so, like I say, a lot of employees and even doctors will struggle with this concept oftentimes. Employees may feel they know that they have a right to accommodation, and so they feel that means they can dictate what they want, what they need, and the employer just has to give it to them, no matter what it is that they ask. And of course, that's not the case. Doctors, similarly, often will say in a medical note, for example, that that may be provided in response to what the employer requests, as Alex will talk about in a minute. They may say, this is the accommodation the employee requires, full stop, period. That's really not how this process is legally supposed to work. How it's supposed to work is that the medical information and what the employee is requesting are considered along with the operations of the employer and the impact that may have in assessing different options in order to provide a reasonable accommodation that balances the employee's medical limitations as well as the operational requirements and the needs of the organization as well. And so that's a process that you really need to understand that distinction between and make sure that you're considering, what's appropriate. It's not at all uncommon that there are multiple different ways an employee's disability limitations could be accommodated. And in many of those cases, there's one that is significantly less impactful on the organization's operations. And as long as that option is a reasonable accommodation for the employee's limitations, that's fine. You can provide that, even if that's not what the employee really prefers. So with that, I'm going to pass it over to Alex to talk about requesting medical information.
Thanks, Joel. And thank you to all of those attendees who are with us on what, at least outside my window, is a very beautiful day. So we extra appreciate you spending the time to go walking through this disability management process with us. So as Joel touched on, a really key aspect here and a big tool in your disability management toolbox is requesting medical information. So this is where we're going to start diving into some of the more practical issues that employers encounter, because it's a really, really important thing to understand how employers can and should request medical information as part of the process, and specifically with respect to the disability management process, because certainly, as we discussed, in any accommodation process, you need information in order to determine what is that reasonable accommodation that Joel was just talking about. But the disability management process in some ways lends itself more to this, as there's a longer history, particular questions that you can ask and that are typically expected. However, in recent years, we've certainly seen that there's increasing resistance, increasing entitlement when it comes to preferred or perfect accommodations, a perceived entitlement from employees who are seeking accommodations, and therefore increased challenges for employers trying to navigate these types of situations. And so with that, we'll dive into some of the key concepts, and we'll walk you through a couple of scenarios we've seen in our practice as well. So when it comes to requesting medical information, um, the employer is entitled to medical information that it requires to make an informed decision. This doesn't mean that the employer is entitled to any and all information it might want. You're not necessarily going to get absolutely, perfect, clear information, certainly not out of the outset, but you are entitled to information, and this means you're entitled to push back if the employee isn't cooperating and isn't fulfilling their duties, as Joel mentioned in the process. So generally what this means is that you're going to be requesting information with respect to limitations that impact ability to perform duties and prognosis for recovery. Those are your two big buckets, medical limitations and prognosis. And that's typically what you want to be asking the doctor for. You're not going to be asking for details of the medical condition or the employee's diagnosis. This is not information that the employer is entitled to. And in fact, when you know this information, whether it's because you inappropriately ask for it or because the employee has chosen to self-disclose, it can actually lead to more complications and an increased likelihood that an employee is going to say, oh, well, the way that the employer conducted itself towards me was somehow discriminatory. They did this because of the stigma associated with my illness or some manifestation of that. So in addition to being information that you shouldn't be asking for from a legal perspective, from a best practice perspective, you want to make sure that you're avoiding this, and you shouldn't be encouraging employees to disclose this information. Now, what does it mean when we say, the type of information that's required to make an informed decision, and how do you actually get that? Often what happens is the employee will, as Joel said, say, I need an accommodation. And sometimes you get a doctor's note that says the employee is totally disabled from performing their job. Or it says the employee needs, to stay away from work for 3 weeks. Something of that nature. No specific details, nothing that actually gives you specific limitations really, or a prognosis, because often these notes are coming in a sequence. You'll get a note off for 2 weeks, then maybe an additional 2 weeks, then 3 weeks, and it can go on for some time if an employer doesn't get actively involved. So rather than um, leaving the ball in the employee's court for them to bring whatever doctor's note they choose to bring without detail, our recommendation to employers is almost universally that you want to prepare a specific letter to the employee that you ask them to bring to their doctor that seeks the right information that you need. And this involves asking some very specific questions about the employee's medical limitations, because in doing so, you can also be providing the doctor with information about the job. You may include the employee's job description, you may highlight specific tasks and duties so that you can ask more relevant questions. So rather than just saying, can the employee work, or relying on information that says the employee can't work, you are going to want to be asking, well, does the employee have limitations related to how the work is performed? Here's a list of their key duties. Can they do these things? If they can't, when do you expect that they're going to be able to do these things? If they can't do them for the full day, is there a limitation on the hours? So this allows you to get more information that's going to actually allow you to consider your operations and how you might reach that reasonable accommodation. Again, not necessarily the perfect one that the employee wants. It also lets you ask about prognosis. Again, when might this situation improve? And ultimately, when is the employee going to be able to work without limitations? Now, in an ideal scenario, you're preparing these letters, they're very clear, you give them to the employee, they give them to the doctor, and they sign a medical authorization allowing the doctor to give you the information, and then the doctor gives you the information. In practice, again, as we've mentioned, we're increasingly seeing resistance to this, further unclear doctor's notes, and either, challenges from the employee saying, well, I don't need to give you any more information. My doctor already gave you a note. Or sometimes even challenges from the doctor saying, well, no, I gave you information 6 months ago. Why do you need more information now? And the reality is that as an employer, you want to be pushing, and you're entitled to push for, again, that sufficient information to make your informed decision. And this is really part of that procedural duty to accommodate that Joel was mentioning, because your disability management process is only as good as your most recent information on what the limitations and prognosis are. And there have been recent decisions from courts and from arbitrators in the unionized context to find that, for example, an employer didn't fulfill its duty to accommodate when it, when it denied an employee's request to return to work after they provided an insufficient medical note, but then the employer didn't inquire further and didn't require more information. So just because the medical note is insufficient, that doesn't eliminate your responsibility to be asking to make sure you have sufficient information. But similarly, it'll be found that if the employee doesn't actually cooperate in the process and doesn't give you the information, that they're likely not fulfilling their duties. And we'll touch on that in just a minute. A further layer of complication that we'll add, which Joel will also talk about later on, is that sometimes employers go about requesting medical information indirectly. So you may, for example, with respect to disability benefits, have a provider who's assessing it, or a third party that's adjudicating the claim. And then as the employer, you may be inclined to rely on medical information that you're getting through a different avenue, where you're not getting the specific information, you're just getting a third party's decision. This is a rather common mistake by employers when it comes to requesting medical information, because you're not necessarily getting the full picture. And we have in our practice frequently had to speak with clients and say, okay, well, this is the what your third party assessor is telling you. You actually should probably be requesting additional information, making sure that you have what you need in order to make sure that you have everything that can make your decision actually supportable. And again, this is something that Joel will be specifically diving into later, so I won't spend too much time on it now. Ultimately, if the employee is refusing to provide you with the information you need, the doctor refuses to respond to reasonable, relevant questions, there may be additional avenues that you can explore, such as requiring an employee to request even further information from the same doctor, or maybe even attend an independent medical examination with a third party of the employer's choosing. Often employees, and where there is a union, unions are quite resistant to the independent medical exam. And these processes do tend to take some time and they tend to be quite expensive. There are situations in which it's appropriate, but often we find in our practice that employers are inclined to say, okay, well, we got a doctor's note, we asked for another one, it's not great. Can we just go to the independent medical exam? The quality of the information that you're gonna receive is usually, dependable. It's quite clear. You'll get a lengthy report back, but it's not something that you can immediately jump to. You really have to follow these procedures and make sure that you're taking steps. And you may very well have to go to the employee a few times and to their doctor a few times, or to a specialist if there's a specialist with more relevant information, before you can escalate to something like an independent medical assessment. Now, we did touch on the fact that doctors and, our practices we've seen from assisting hundreds of clients through, countless of these types of situations are becoming somewhat less willing to answer questions. And sometimes it gets challenging to get information from them. And this is really being exacerbated by the trend we've seen across jurisdictions in Canada when it comes to implementing some degree of ban on sick notes. So in Ontario, pursuant to the Working for Workers 5 Act, which is still under consideration, employers would be prohibited from requesting sick notes in relation to statutory sick leaves. Other provinces like Quebec, Nova Scotia, New Brunswick, PEI, and Newfoundland and Labrador have also either legislated certain limitations on these types of sick notes, whether it's you can only request a sick note after a certain length of leave. But this being in the media and this being discussed generally is getting employees' attention. So they're creating more challenges for employers getting information, and doctors are similarly saying, either I don't want to provide this information, or I'm too busy, or in certain circumstances, we even had pushback from doctors where they question the types of questions we're asking and the fact that we're not just giving the employee exactly what they want in terms of a perfect accommodation. We had a case not too long ago in which it pertained to accommodation with respect to mental health, and the doctor felt that it was appropriate to essentially get on a soapbox and comment on the fact that, well, if this was a broken leg or something, you wouldn't be asking for any of this information about limitations or prognosis. You would have just let her have a leave. Well, no, that's not how it would have worked. The employer in this case was actually behaving in exactly the same manner and following all of the legal requirements and best practices that it would for any physical injury. But it is, again, getting more difficult for employers to manage these circumstances, which is why having those questions, thinking about them really carefully and considering what type of information you're requesting is very, very key. So all of this goes back to those duties that Joel touched on that I'm just going to reiterate, and that employers have the duty to inquire for further information where information is insufficient. If you aren't requiring that additional information, you may be found to be not fulfilling your procedural duty to accommodate. And employers really can't rely on the employee's opinion or assessment. The employee, in most circumstances, is not a medical professional. They're not qualified to tell you exactly what the limitations and prognosis are. And certainly, if they're just jumping to this is the accommodation that I need, that's not going to be sufficient to make sure that you're actually meeting all of your obligations. And it's really important to communicate to employees in policies, in practices, and in the disability management process that they have a duty to cooperate in the process by providing the information that you need. So I'd walked you through a couple of cases where the employer's participation in the process was deemed to be insufficient. There was a recent case from the Human Rights Tribunal of Ontario last year called Leeson and Adamanda Incorporated. They were operating as Dairy Queen Grill and Chill in Huntsville. And in that case, the employee worked intermittently at this ice cream and fast food restaurant for about 3 years. It also happened that her manager was a family member, which was relevant to part of the claim. But in April 2017, she suffered a concussion at work, which led to a week-long medical leave. When she returned, she subsequently fell ill during a shift, left early, and then just didn't report any of her subsequent absences. She didn't say if she was coming back, she wasn't responsive to communication, and she was ultimately removed from the work schedule for some time while there was discussion about her return to work date. Several months later, in December of 2017, at the employer's request, she returned to work and then continued working until March of 2018, when she requested some time off for a doctor's appointment, which the employer granted. And then she didn't come back to work. And when the employer attempted to follow up with her, she sent a message saying, "I don't plan on coming back at all." The employer, in our view, reasonably interpreted that as a resignation and thought that the employment relationship had ended. The employee ended up filing an application with the Human Rights Tribunal alleging discrimination on the basis of disability and reprisal, that she had been somehow punished as a result of her disability. Ultimately, in this case, the tribunal found that while the employee did have a disability, there wasn't any concern here with the employer's conduct in the disability management process, because the employee neither requested accommodation clearly nor actually engaged in the accommodation process. The employer was trying to get information, and it just wasn't able to get what it needed. The tribunal ended up holding that given the employer's limited knowledge, it would have been really inappropriate for the employer to assume that the employee required a particular accommodation without a specific request or supporting documents. So again, it's really important to make sure that you have that information, and it's really important to be communicating to parties in the workplace that they have the obligation to provide it. And just to touch on, as Joel mentioned, this goes to other parties in the workplace. So if your workplace is unionized, the union also has a duty to work with the employer and work with the employee and make sure that everybody is getting together to facilitate an accommodation process that results in a reasonable accommodation. And we've certainly in our practice had a number of occasions where we've had to assist the employer in a communication to a union who's been saying, "Oh, well, um, this employee doesn't need to provide any more information," or "this is exactly what the employee needs," to say, "Look, this is not how the process works. We need more information. You have a duty to help this process out, not obstruct it. And this is what that means." So, with all that, I'm going to turn it back over to Joel to focus us in on the mental health accommodation piece and all of its intricacies.
Thank you, Alex. So as Alex mentioned, as I mentioned earlier, we're going to spend some time here on mental health because it is just such a particularly challenging element of disability accommodation these days, and it's becoming, more and more so. So when we're talking about accommodating mental health, let me just start off talking about generally what that definition for mental health disability would tend to include. So human rights adjudicators have found that mental health or mental illness disability includes things like psychiatric disabilities, mental health disability broadly, psychosocial disabilities, substance abuse and addiction. Those both amount to mental health disabilities as well. So, it's a broad category of types of disabilities. And in all cases, for a variety of different reasons, these really are particularly complicated for employers to manage. In many cases, the employee may not self-identify their mental health situation. They may not recognize it themselves, or even if they do, they may not be as willing to share. Of course, historically, there's been a pretty significant stigma associated with a lot of mental health disabilities. That fortunately is, continuing to reduce societally, and so that does make it more likely that people are not going to feel that shame related to it. And so if they understand, they recognize they do have this disability, they may be more willing to share it than they were before. But that there is still some stigma, and so there is still the reality that a lot of employees won't come out and share this information in this detail with their employer, even where it may be impacting their ability to work. And so that, again, makes it really a lot more complicated as an employer to deal with that situation. Um, as a result of that, that duty to inquire that we spoke about before, that requirement that where there's reason to believe that maybe there's an accommodation need here, the employer does have that duty to inquire into that. That's going to be even more important when it comes to mental health. Unfortunately, with that, it's also much more likely that that duty to inquire, when you do comply with it, could upset the employee, right? They could very easily take offense to the suggestion that they may perceive it as a suggestion that they have some sort of mental illness when you're really trying to comply with your obligations and ensure you provide this employee with what they require to be able to participate in the workplace, right? And so it's of course really important that employers are careful and take careful steps when they do comply with that duty to inquire, and exactly how to do that is going to really be case by case depending on the circumstances. But you certainly want to mitigate that perception that employees may have. So this really is much more difficult for employers to deal with than a physical health disability, which tend to be more straightforward. They in many cases are visible, or the employee is much more comfortable talking about it, right? And so it's easier for employers to understand where there is an accommodation need and then what those limitations might be as a result. So this is of course becoming more and more prevalent for employers, and also again becoming more challenging for employers. So of course, broadly, there's an increase in diagnoses of mental health disabilities across really our society. So there's just more of it to deal with as an employer. And then, like I said, it's also the reality that a lot more employees are going to be willing to bring it forward and raise that, and there's more of an understanding around that as well. And so that's going to be, something that really does make it more likely that you're going to deal with it. And I'm sure most of you here today have had to deal with these situations in your workplaces as well. Now, mental health, of course, it's going to be more complicated than physical health. And what that can lead to is family doctors, general practitioners, sometimes aren't going to be fully equipped to adequately provide information to the employer about the mental health limitations that may be associated with that disability. And so that can make it even more challenging as well as an employer. You need to ask for the information. That's one hurdle that I've talked about, but then you may not actually get the information that you require from the GP. And so then you may need to think about going to a specialist. Does the employee have a specialist? And even if they do, I'm sure most of you here are well aware of our health system. It can take a while to see a specialist, right? Even if the employee is already associated with that specialist. So that can take some time. And then that delay is a period when, as an employer, you need to figure out what you're going to do with the apparent limitations that you're already dealing with. And so that can be a challenge as well. The other thing to consider, as Alex was talking about, is that idea of an IME, an independent medical examination. You can typically get to an IME more quickly, but they are costly, and employees and unions will often push back on the idea of them. And so again, that adds another wrinkle as an employer that you need to make sure that you're properly dealing with and contending with. So when you're dealing with these situations, it really can be a challenge. In some cases, it really is not easily manageable. I'll talk about one instance that I dealt with last year with a client where they had an employee who had a clear, long-standing diagnosis for some significant mental health challenges that this employee was quite open about, and they shared with their employer. So they were fully open about what they were dealing with. But as part of that, this employee often felt that others were discriminating against them. They often felt that fairly typical workplace interactions with all sorts of other coworkers were actually instances of those people discriminating against this employee. And so the employee would often allege others to discriminate against them, would often allege that others are harassing this employee, when in practice, in some of these cases, it actually resulted in the employee themselves harassing the others because of their displeasure and their perception that they're being mistreated by the others. And so as an employer, this is really hard to deal with, and it's not entirely unusual. That was a fairly extreme case, and I didn't give a lot of the details there that our client dealt with, but that was a fairly extreme case. But that general idea that mental health does impact employees' conduct and their perception of what they require, that's a pretty common thing that employers need to deal with. And in some cases, when you deal with mental illness, the employer then has to think not only about accommodating that employee and ensuring that employee's own health and safety, but also think about the idea of health and safety of their coworkers and protecting them as well. Because I'm sure most of you know, under occupational health and safety legislation across the country, just like you have a duty to accommodate employees with disabilities, you also have a duty to take every reasonable precaution that's necessary in the circumstances to ensure employees' safety, right? And so then these then become important competing priorities as an employer that you have to contend with. So in dealing with those sorts of situations, you have to balance two truly fundamental obligations as an employer that you have: employee health and safety and employees' human rights. These are some of the most closely guarded rights of employees in our society, and for a really good reason, of course, right? They're both incredibly important. And so where they may conflict with each other, it can become challenging as an employer to determine what to do. Well, there is some guidance for employers that come from the law that can help in determining what to do about these situations. There was an arbitration decision a few years ago in Ontario where an arbitrator dealt with a situation where an employee who had a diagnosed mental illness disability, where there was a concern about bringing that employee back to work and whether that would create a safety risk for others in the workplace. And so in that case, the arbitrator looked at the situation and considered 4 factors, came up with a list of 4 factors that other adjudicators have followed since, in order to determine, what to do when determining whether you need to bring somebody back to work, and whether it's consistent with legal obligations not to bring somebody back when they have a mental health disability because of safety concerns for others. And so in that case, those factors to consider: what's the likelihood that an injury to the employee themselves, the employee who requires the accommodation, or to a fellow employee in relation to that, what's the likelihood that that injury might occur? And if there is an injury that's likely to occur, is it likely to be serious? So that's the second one. Is it a serious injury? Third, who's going to bear the consequences of that risk? So if something happens, who's facing the liability in that situation, and also who's going to be hurt as a result? Is it the coworker? Is it the employee themselves? What have you? And then ultimately, the fourth factor is the risk that we're looking at there, is that acceptable in the circumstances? So this provides some clarity. I imagine some of you may be looking at me right now and thinking, well, that's about as clear as mud, right? And this does happen with the law. Sometimes these tests that are implemented are also pretty tricky to follow, but it does provide guidance, certainly, for you to consider, and some factors to go through if you're dealing with these situations. And if, as an employer, you in good faith consider those factors and document that can really help in showing that you're taking the appropriate steps, and ultimately mitigating the risk by taking the right steps to care for your employees. So, this duty to consider the risk to others in the workplace, that is, of course, a crucial element of any accommodation process, and certainly any mental health illness accommodation. So that's something you want to consider in any event, but certainly, where there's a real risk and a real concern for that. Now, this is challenging, and, as Alex was talking about before, it's the same thing with mental health disabilities as with others. You need to ensure as an employer that you have adequate medical information, not the information you're not entitled to, but get that information that you are entitled to help guide that process. And like I was saying a moment ago, consider, how to get that information, the limitations that you may have, and the alternatives that you may have to get the right medical information from professionals who truly understand the issues at play. Where you're considering these things, you need to consider all these different legislative obligations, the human rights obligations, the occupational health and safety obligations, and of course, sometimes there are others as well. And ultimately, you consider that medical information that you have, consider the factors, and determine, what's an appropriate step to take. So another element of accommodating mental health disabilities that really can create a lot of challenges for employers is the reality is dealing with mental health disabilities makes it a lot more likely as an employer that you're going to deal with allegations of discrimination or bad faith treatment by the employee. An example of this may be where the employer has decided to dismiss an employee, and typically that's going to be for reasons unrelated to the disability, but where they've made that termination decision, and then all of a sudden the employee takes a stress leave, right? That's a situation that I'm sure many of you have dealt with. Unfortunately, that is a fairly typical thing to happen. And so these types of situations, create complicated circumstances as an employer. On top of that, it's really become commonplace, unfortunately, that after employees are let go, they'll, through their lawyers, make all sorts of allegations of wrongdoing against the employer. Often they'll allege that the employer discriminated against them or failed to accommodate some disability that in many cases the employer didn't even know about, like the case Alex was just talking about. They may allege that the employer was treating the employee in bad faith in some way. And this is often done strategically in order to try to create an opportunity for reaching a settlement where the employer is concerned about the risk being raised, and then if that settlement is reached, characterizing some of the settlement money as what's called general damages, which are generally not taxable. So they're trying to get more money into the employee's pocket as part of that settlement as well. Now, there's reasons why they may do that for, in those circumstances. Of course, as the employer or the manager or the HR professional, nobody wants to be told that you've discriminated against somebody where, in most cases, you're working really hard to try to make sure you're complying with your obligations and deal with a complicated, challenging situation as respectfully and as appropriately as you can. Right. And so, where that happens, that can really make these negotiations more difficult. I'll just say as a brief aside, this is, it's a bit of an aside here, but I'll say if you find yourself in that situation, there's a demand letter from a lawyer alleging that something that you did in your work, whether you're an HR professional or a business owner or what have you, that amounted to discrimination, just bear that in mind, that oftentimes those are strategic steps that they're taking, and the employee may not even truly believe that that's the case. Maybe cold comfort for many, but it is something to bear in mind. Now, as a result of these situations and the real significant damages that we'll talk about later that employees can be entitled to if they prove that a dismissal was discriminatory, that they weren't accommodated, employers need to be really careful to mitigate the risks that I'm talking about here, right? So, if an employee is potentially going to be dismissed because of some sort of performance issues, you want to document that as an employer. That's a really crucial thing. Document it clearly. And where there's also accommodation issues that you're already aware of, sometimes you don't know while you're dealing with, coming up to that termination decision, like I said, but where you are aware of some sort of accommodation situation, deal with those separately, right? Performance and conduct and accommodation situations, they generally are separate. They can bleed into each other. Of course, there can be overlap where the employees, mental health issues are impacting their conduct, what have you. That certainly can be the case, but oftentimes they really are distinct. And as an employer, if you really keep them distinct in how you document it, how you deal with the situation, when you communicate to the employee about each different circumstance, that can really go a long way in mitigating against those risks that I'm talking about. Now, where you do deal with a situation, like I mentioned, the employee goes on stress leave right before the termination decision is carried out. Then you want to make sure that in those circumstances that you're accepting the accommodation request in good faith, unless there's a very clear reason to doubt it, beyond just the circumstances seeming suspicious on their own. But with that said, if you've documented your termination decision, oftentimes you can continue with that termination decision and greatly mitigate the risk where you've documented it appropriately beforehand. So the last thing I want to discuss when it comes to accommodating mental health, this is maybe a bit of a preview for the Investigations Hotspots webinar in a couple of months. When you're dealing with accommodation of mental health disabilities, this is something that's coming up more and more in workplace investigations in all sorts of ways. Of course, mental health can have impact on the conduct that's in question and being investigated. So it may be that there's allegations by somebody who, as a result of a disability, a mental health disability, is perceiving some sort of issue or perceiving that they were treated inappropriately, when in reality that was not the case, and it's a result of their mental health disability. That's like the situation that I was talking about a couple of minutes ago. In other cases, oftentimes we'll deal with situations where an employee who has mental health disabilities acts in a certain way as a result of that, and so then they may commit some sort of misconduct and they become the respondent to an investigation. That's the other part of the example that I was giving. Sometimes it's the same situation where the employer is dealing with from both ends. And so, that's something that really needs to be considered, and it's part of why it's so complicated to investigate. It's part of why, investigating from a trauma-informed lens and with an understanding of diversity and inclusion is so important, because when you're doing these investigations, you need to understand those types of implications and how those impact conduct and what really happened. In addition to that, there can be in some cases more straightforward situation where a participant in an investigation, whether it's the complainant, whether it's the respondent who's facing the allegations, whether it's a witness, whatever the case may be, they may require some sort of accommodation in order to cooperate in that investigation process. It may impact, how they can be interviewed, where they can be interviewed, whether they need a support person present, whether being interviewed in writing might be a more appropriate way to deal with the individual. There's of course so many others, but those are some pretty common ones that you can deal with in dealing with investigation situations. And as an employer, again, you just need to be mindful of that and all those same obligations that we talked about earlier about when that duty to accommodate is triggered and how you're supposed to deal with it in communicating with the employee, getting the medical information, all of that. It all exists in the same way in the context of an investigation as it does in the context of an employee who just isn't capable necessarily of performing all of their duties day to day as a result of a potential accommodation need, right? You follow those same steps to comply with your obligations and effectively manage the situation. Now, these are not hypotheticals that we're talking about. These are things that we see in our practice all the time when we're advising our clients who are conducting workplace investigations, as well as when we're conducting investigations as neutral third-party investigators for others as well. And there's also case law and a body of case law that's really starting to develop in this area as well. So just last year, there was another Human Rights Tribunal decision. This is a case called Rojas and MMCC Solutions Canada. And in that case, there was an employer who was ordered to pay some pretty significant damages for dismissing an employee who had autism after they investigated complaints against the employee in a way that was found to be improper. And if you want more information about that, we have written about that recently on our blog, so you could take a look there. So in that situation, there was an investigation conducted because the employee was alleged to have inappropriately hugged a variety of their coworkers. In the investigation, the HR director spoke to the employee, didn't give a ton of context based on what the Human Rights Tribunal found about the allegations, but just spoke broadly. And the employee tried to share during that interview that they have autism and it impacts, their conduct and their understanding of what was appropriate. And they were told during that discussion that having autism is no excuse for committing harassment. The employee was then let go for cause. And so in that case, the HRTO didn't have too much trouble in finding that the employee's disability, their autism, was a factor in the dismissal. And although the employee did engage in the behavior that was found to be harassing, the employer was obligated to take into account that disability and determine, whether and how that would be accommodated in the process, which the employer failed to do. And so as a result of that, the Human Rights Tribunal awarded around $40,000 in damages against the employer for taking that step. And so, again, had that employer really been mindful and understood the implications and the impact that this mental health disability may have had on the process, that may have been able to be mitigated pretty significantly. Okay, so with that, I'm going to pass it back over to Alex to talk about disability management and how it relates to remote work.
Thanks, Jill. So certainly, a lot's been going on in a lot of different areas of law that's given employers a lot to think about and different areas to navigate. And remote work in some way, shape, or form has been around for a long time, but certainly the prevalence of it is really a function of the last 4 years post the COVID-19 pandemic. So what does this mean in our current workplaces? We're going to start with just a little quick recap. So I'd like you all to recall, and I know we've mentioned this a bunch of times, we're going to keep mentioning it throughout this webinar, the really important distinction between that reasonable accommodation, which is what you have to provide as an employer, and the perfect accommodation, which might be what the employee wants. And from a disability management perspective, what this means is that increasingly, employees are requesting to work from home some or all of the time as their perfect accommodation. And I apologize, I think my slide is just lagging a little bit here, but I'll keep going in hopes that it will catch up. There we are. So in these types of circumstances, when the employee is saying, I need to work from home or I want to work from home, employers should be assessing the accommodation requests, again, take them in good faith, but look at them critically and consider the specific circumstances as you would for any accommodation request, because the reality is the work from home is not always warranted. And we'll give you an example of something that we assisted a client with recently. There was a circumstance in which the employee in question was a receptionist, so worked at the front desk 5 days a week, came in every day. And then during the pandemic, the employee was permitted to work from home because the office space was closed. So the interactions with customers, clients, vendors became different for a period of time. During this time, it happened to be the case that the employee injured their back and ended up needing to take a lengthy leave of absence. And once the employee was ready to return to work from this leave of absence, the office had become open Their position was to be an in-office position again. They were needed back at work, but the employee wanted to keep working at home. They insisted that they needed to continue doing so because of limitations related to their back injury, which on further inquiry turned out to be limitations related to lifting things. As part of their role, when deliveries came, they would typically pick things up, packages, and then distribute them or put them wherever they were necessary in the office. So in this case, the employer, on our advice, pushed back on this and had the doctor clarify that the recommendation to work from home was just a recommendation. It wasn't an actual requirement. The reason for the recommendation was this limitation related to lifting. In this case, the employer was able to determine that a reasonable accommodation might be that the employee comes back to their receptionist job. If packages are delivered, they can let somebody know and somebody else would come and retrieve them so the employee wasn't lifting. That was a very, very small part of their job, so it was very reasonable for them to continue to fulfill the rest of their duties in the office. In this case, this wasn't the employee's preferred accommodation, and as a result, the employee didn't like it and ultimately resigned from her job. So, you know, the employee didn't return to work. However, the employee departed, allowing the employer to take steps to make sure that that position was filled. And because the employer was careful, and made sure that they were asking the right questions, again, requesting the information that they needed, pushing back appropriately on what they got, they assured that they were compliant in the disability management process, and ultimately there was no claim and no liability for the employer and how they conducted themselves and the accommodation that they put into place. Now, I will also highlight for you the flip side of this, which is that, conversely, the possibility that work from home might be able to be done for your organization can actually enhance the accommodation tools that you have available to make sure that some work is still performed if that's your preference. And as a result, employers again should scrutinize claims that an employee requires a complete leave of absence. To pull another example, because the stories we could tell you if we only had more time. But in our hotspots, we'll just highlight a few. In a different circumstance, we had an employee provide a doctor's note to an employer saying that they couldn't attend the office. Well, actually, to be more fair, the employee's note said, the doctor's note said that the employee has advised that they were in need of a sick note to be absent from work for 3 weeks. And then the employer kept getting these same notes. So on our advice, the employer pushed back, asking about what are the actual limitations here, why? And initially wasn't getting any information from the doctor. They would just get the same notes. It ended up leading to a potential disciplinary issue because the employee wasn't fulfilling their responsibilities. But eventually, the employee was convinced of the need to participate in the process and took the information that was requested to the doctor, who said, well, actually, the limitation was the employee couldn't drive long distances. They'd moved far away from the office. Um, at some point in their employment. And after they'd become injured, it was an issue to do with a knee injury, and so they couldn't drive long distances. Um, there was nothing that actually prevented them from performing their job, which was 95% desk work. They had some duties that involved going out into the field, interacting with clients and customers in that sort of circumstance. But that wasn't the most difficult part of the job that the employer needed to replace. So in this case, the employee would have preferred to have been at home and actually availing themselves of the disability benefits that the employer had in place. But it was a busy time for the employer. Even if the employee couldn't actually come into work for some time, the employer preferred to have the employee actually working. And so they made that very clear. This is the accommodation we'll provide you. We'll send your computer and various items to your home. We expect you to continue working. In this case, the employee didn't like that and it opened the door to negotiating their exit because they said, well, actually, I don't really want to be here. And again, ultimately, this was another circumstance in which the employee wasn't really reintegrated back into the workplace, but the employer was able to close this page and move on. from this relationship and into a relationship that suited their operations more. So with that, back over to you, Joel.
Thank you, Alex, and thank you all for the great questions. I was just had a chance to take a look at a few of the great questions that we have there, and I know one of them does relate to the topic that I'm going to discuss here as we get toward the end of the content for the afternoon. So, what I want to talk about right now is accommodation, workers' compensation, and disability benefits. So, as I mentioned at the outset, there's some pretty common misconceptions about how your obligations are impacted when you're dealing with a workers' comp situation or an LTD situation, for example. Um, Now, I will just briefly note this relates to the question that we got. So before I get into the kind of meat of this part, there was a question about whether there's any sort of law about how long employees' benefits need to continue in the event that the employee is on a long-term leave on LTD, on long-term disability benefits. And so generally, no, there's not significant laws to deal with there. There is some common law that needs to be considered, though, in dealing with these situations. So as a general concept, employees are entitled to benefits at the same time that they're entitled to wages. So generally, benefits are considered legally to be compensation in exchange for work. And so if employees aren't working, there's no default obligation on the employer in order for them to provide those benefits on an ongoing basis. Now, there are, of course, limitations to this. Under the Employment Standards Act, employees who are on a protected leave of absence under the Employment Standards Act, their benefits have to be continued. And if there's a copay, they have to be continued as long as the employee pays their portion of the benefits. So that part's quite clear. When it comes to workers' comp, employees on leave through WSIB, their benefits have to be continued generally for a year before there's the right as an employer to discontinue those. But there are human rights obligations that kick in there that you need to be mindful of as an employer as well. And so if an employee's benefits are being cut off because they have a disability, that can be found to be discriminatory and a human rights violation. On the other hand, if the employer has a policy, which is generally the recommended way of dealing with this, the employer has a policy that addresses how long benefits will continue during any form of a leave of absence, not just a long-term disability leave, not just a medical leave, any leave of any sort, subject, of course, to the statutory requirements to continue benefits like we talked about a moment ago. Where you have a policy like that and you're simply implementing a policy broadly across the board, that generally would not be considered to be discriminatory. And so that's typically the best approach for how employers can deal with that to mitigate against those human rights implications. So while there's no specific rule other than those specific circumstances under the Employment Standards Act and WSIB that says benefits have to be continued, there can be significant risk if you don't set yourself up appropriately. So with that, I'm going to dive in really to the key aspect that I want to talk about here when it comes to WSIB and disability benefits. So it's quite common that accommodation obligations and WSIB benefits are being dealt with at the same time. So a typical situation there would be an employee has a workplace injury, they file a workers' compensation claim with the WSIB, the claim is approved, and so a case manager or return to work specialist is assigned to the matter. And then in those situations, it's common that the employee is going to continue working with the WSIB, whether they're on a leave for some period of time or they have some sort of modified work, and WSIB will support in that process. In a similar situation, employees may have a non-work related injury that leads to a leave of absence or disability, whatever the case may be, that leads to a leave of absence, and they go on short-term disability or long-term disability benefits. And so then they're off work for some time, and that's being managed by a case manager of some sort from the disability benefits adjudicator in the case of most STD plans, or the insurer in the case of most LTD plans. And so in both of these situations, it's quite common that employers will not really stay in touch with the employee throughout that process. Oftentimes when it's a WSIB situation, the employer will simply communicate with the WSIB and get the updates there to determine when the employee is able to take on more work or when the employee is able to return from their leave, as the case may be. And in the case of disability benefits, on the other hand, it's quite common that the employer will get the updates, the intermittent updates that the disability benefits provider or adjudicator will provide to them, and they'll essentially wait for those until that individual from the in the case of LTD, from the LTD company, until they say this employee is ready to start a graduated return to work, and then they start communicating directly again with the employee. And I should say right off the bat here, I get it. I get that approach. There are people at the WSIB or at the LTD insurer whose job it is to support that employee. And those people have access to a lot more medical information than as an employer you're ever going to have access to. So they have access to more information to help them understand what steps to take. And so I completely understand the inclination to just let those individuals do their job until this employee is ready to come back. I also understand that oftentimes employers may be concerned that communicating directly with the employee will cause the employee to be upset. The employee is on leave, they're trying to recover, they don't want to deal with their employer during that time. And so the employer thinks it's respectful to let that employee be. And that may be the case, but from a legal perspective, from a human rights accommodation perspective, that's not typically the best approach to mitigate risk. So I'll give an example here. I had a client where an employee suffered a pretty serious workplace injury. It was a physical injury that led to some mental health issues. And so that employee was off on WSIB leave for years. Ultimately, the WSIB case manager indicated that this employee wouldn't be able to return to work as a result of the injuries. And so in the context of resolving the employment relationship, which involved a frustration of contract, which is common in those situations, the employee got a lawyer, and the lawyer said, well, the employer failed in their duty to accommodate. They didn't meet their procedural duty to accommodate by staying in touch with the employee throughout the leave, and rather letting the WSIB manage the process. And there is some case law support for a situation like that. Now, this is also a situation where the employee had mental health disability resulting from a traumatic incident at work, and it was very respectful of the employer to let the employee be. And frankly, I would expect that had the employer been touching base with the employee regularly, the argument would probably be the opposite, that they were, treating them in bad faith or unfairly by communicating with the employee on their leave. And so to a certain extent, there's a concern that these are no-win situations as an employer, and I can understand the validity there. But with that said, that procedural accommodation duty continues to apply no matter what type of disability the employee is dealing with, no matter whether there's an LTD insurer or the WSIB involved in the process. And so employers do still have that obligation to be getting information where appropriate and communicating with their employee in order to manage the accommodation process. You won't necessarily need to touch base frequently by any means. Oftentimes it can be very intermittently, but staying in touch with the employee is the way to meet your own obligations as an employer. And so, when you go through that WSIB process, you complete your Form 7 as the employer. The case manager or the return to work specialist or both are assigned, and you're touching base with them. Again, just stay in touch with that employee as well to some extent, and unless there's very particular circumstances suggesting otherwise, to make sure that you are meeting your obligations and having the communication with the employee that you need to have. That can also practically lead to benefits where you may understand what the employee is really looking for. You may be able to come to some common ground outside of the kind of strict WSIB process. And again, that's because you have to meet that procedural accommodation duty. Similarly, when it comes to disability benefits, entitlement is frequently assessed by that third party, this short-term disability adjudicator or the long-term disability insurer. And you may not get regular updates, but you do get them here and there from that insurer. But regardless, as an employer, throughout that process, you should be in touch with your employee and getting the information that you may need in order to manage that process. Okay, and so with that, I'm going to pass it back over to Alex to take us through one of our last segments before we spend some time with some questions.
Thanks, Joel. So just briefly, we want to highlight for you some of the, as the slide says, costs of getting it wrong. And not all of these costs are dollar and cent costs. These are more include some of the complications that may result if these matters aren't dealt with promptly. So just to dive on in, one of the first ones that we've touched on here in a number of the examples we've shared is that if you're not being proactive, if you're not getting the information that you need, sometimes these disability management matters can span years. It's happened that employers have come to us, as they're doing some administrative work and found that they have employees on payroll that HR doesn't even remember were employees. They've just been, they went on a leave and they never came back and nobody's heard from them. In certain circumstances, they've been working for years elsewhere. In certain circumstances, nobody's really sure what the situation is. Really, and it takes some time to figure it out. But without getting that information or without asking very specific questions, you can have some of these issues lingering, and then in some ways getting potentially more expensive and more complicated. It can also lead to negative employee morale, because if disability management isn't properly undertaken and employees perceive, have the belief that somehow their colleagues are um, malingering, not necessarily being honest in some of their perceived reasons for disability management need, that can create problems. And this is very difficult for the employer to navigate because, again, you have the obligation to take accommodation requests in good faith. So you can't necessarily be taking the position that everybody is, not telling you the truth. Although you may know that some employees are. Again, you have to follow those procedural steps. And if it comes to be the case that employees are taking advantage, pushing for accommodation that they don't need, but then others may also want. The work from home one is a very good example of that. You have to make sure that you're doing your due diligence, that you're getting the information you need, and making sure that you're behaving in a consistent manner across employees and consistent with your policies and legal obligations. Ultimately, should some of these relationships, end up ending or, ending poorly, there are some damages that can result. The most common damages tend to be damages to injury to dignity, feelings, and self-respect. Those were in some of the examples that Joel shared with you, and these tend to be paid as a lump sum. Typically, they range on the low end from $10,000 to $40,000 these days. That's quite an increase from, say, 5 years ago, where they tended to be quite lower. And the reality is that legal decision makers, particularly at the Human Rights Tribunal of Ontario, are now fairly backlogged. So, it's to a certain extent difficult to assess if you have a matter now by the time it comes to a hearing. The range of damages might be significantly greater because they have been increasing as there's been more consideration for the impact that these types of issues have on employees. I will just give you a quick example of a situation that actually happened in BC. So it's not binding in Ontario, but decision makers in Ontario, for example, do consider other jurisdictions persuasive. There was a situation between a minor who was an actor hired to play a lead in a musical and the Kelowna Actors Studio. And the actor was diagnosed with neurodivergent conditions and was dismissed by the employer a few days after rehearsal. He was dismissed via email. As a result of the manner of dismissal and the failure to accommodate, there were significant impacts to his health. The employer in this case admitted to taking no steps to manage or accommodate the employee's disability and was ordered to pay damages for lost wages, which were fairly small, $1,200, but also injury to the employee's dignity, feelings, and self-respect of $35,000, and expenses incurred due to discrimination, including counseling and medical expenses of up to $20,000. And additionally, because tribunals do have fairly broad powers to generate awards, again, it's not all dollars and cents, the employer was also ordered here to enforce practices such as sensitivity training and educational programs, implement a policy that was relevant to the circumstances, and adopt an employment equity program. So really there's, quite a number of different things that could be at play, including those damages, including the lost wages, and then sometimes for many years, if the matter has gone on for a very long time. And tribunals can, in certain circumstances, award reinstatement. So if in fact it's been your position that the employee should be removed from the workplace, their employment should be ended, there is a possibility that that employee could come back into the workplace with now a sense of entitlement and feeling that, they're Teflon, essentially. They're bulletproof. They can do whatever they want because there was a dispute with the employee and ultimately they were successful and they're back in the workplace, in addition to the wrongful dismissal damages that can result if the employee goes to court and is successful, which, the analysis of this kind of goes beyond this particular webinar, but certainly there can be significant damages here usually, except in extreme circumstances, up to 2 years, sometimes less, depending on length of service and other factors. And so I'm going to turn it back over to Joel for some key takeaways to bring us on home before we get to your questions.
Great. Thank you again, Alex. And so, like Alex said, the key takeaways here, I'm going to be quick to make sure we have as much time as possible for your questions. So what are some of the really important things you want to take away from today? You want to make sure that you're flexible in providing accommodations, get the medical information, communicate with the employee, and take different situations into account. You want to make sure in the accommodation process, when there is an accommodation need related to disability, you're seeking medical information. But as Alex said, ask the right questions and don't ask the questions like about diagnosis that you're not entitled to in most cases, and that could create other liability for you. What you're trying to do really is help yourself manage the process and reduce liability. And so just make sure you're asking only those right questions. When you do have those employees on leaves of absence, even if it's WSIB covered, even if it's disability benefits covered, stay in touch with those employees intermittently, get the updates that you need, including in some cases getting medical updates, to make sure that you are continuing to meet that procedural accommodation duty that you will have throughout those processes. In addition to that, make sure that you're training your managers to effectively manage remote employees. A lot of the situations that can arise with remote workers, including when the remote work is a form of accommodation, they can be dealt with effectively through training those managers to deal with them properly, to understand how to look out for issues, and also to understand when there may be an accommodation need, because it's a lot harder to know when that duty to inquire is triggered when you're not face to face with the employee. And so, managers need to be equipped to deal with that properly. Of course, make sure that you do have an individualized approach for each accommodation situation. That's going to always be important in this process. Accommodation is always a case-by-case assessment and needs to be that, even where there's guidance and there are principles to bear in mind. And finally, be creative in creating accommodations. You want to make sure that you are considering what accommodations are possible. And this one is especially relevant when it comes to that classic work from home accommodation that I know we've spoken about. I know some of your questions relate to as well. Be creative when you're creating those, and consider, what other things can you do to accommodate that employee. Figure out what the limitations are, not just what the employee or their doctor wants, and figure out whether there's some other way to accommodate that situation. So that brings us to the end of our content here. Just wanted to provide a quick reminder, like I said at the outset, we have 2 more Hotspots webinars coming up. The next one on October 17th, same time, noon Eastern time, talking about terminations. And then another one talking about investigations on November 21st. And so that brings us to the end here and to our Q&A segment. And so I'll make sure that we're both up, and Alex and I will take some of your questions right now. And if you have any that you haven't had a chance to drop into the chat, please go ahead and drop them in there, into the Q&A, excuse me, not the chat. Let me be clear and not confuse everyone. Please go ahead and do so. So we've covered off the first couple of questions here. I'm going to pose this next one, Alex, to you. So this is, I'm not sure if this is a true quote or essentially a quote, but I'm going to just provide the question here. So the quote is, "I'm not feeling well today, so I will work from home." This is a repeated email that's sent to the manager each of 3 out of 5 days for this hybrid work. It sounds like it's a hybrid role involving 3 days in office. What can that manager do? And I'm going to just say that the caveat here that we always say in these situations, we're providing legal principles right now. We can't provide specific legal advice without all the circumstances, but certainly we can give you some guidance here.
And that's, a great question. Unfortunately, it's going to depend on the circumstances, which is why, as Joel said, we can just provide you with the general principles, because some of the things that are going to matter are, what are your policies with respect to what kind of information you can ask for? What are your practices? How long has this been going on? What's the nature of the employee's work? But generally, you're going to go back to some of the first principles that we talked about, which is request appropriate information. Why are they saying, first of all, they're saying, "I'm not feeling well, so I'm going to work from home." That begs a whole suite of questions. One is, well, if they're not feeling well, can they even be working? If they're not feeling well 3 days a week, are they actually producing sufficient work for you? Are they actually being safe? Because that could be anything from I'm a little bit sniffly and I don't want to infect my colleagues, to, I'm experiencing a significant health issue that's impacting me either physically or with respect to my cognitive skills. And so the first step would be making sure you're getting information and asking for that, sending out that letter, making sure that you have the specific information, and then depending on what comes back, as we said, there are a whole host of different directions that you might be able to go in, from saying, okay, well, maybe you need to be off work just for some time, to saying, absolutely not, come back into the office or there will be discipline.
All right. And Alex, let me stick with you for one more question here. And this is an interesting one. I think this relates, or I think it probably arose in the event through the requesting medical information section. And so the question here is, what if the employee does not want to seek treatment? So they don't want to take medication, and I guess is the example we're looking at here. So such that the employee's condition and limitations will not improve. How do you deal with
Mhm.
that as the employer?
That's a very interesting question. That could be a very difficult scenario. Again, you're going to want to make sure that you do have medical information that relates to the prognosis and the limitations, because it may be that the employee can work with their condition as it is, whatever the condition may be, and that you're able to find some type of reasonable accommodation in the workplace. It may be that if the condition is something that's very significant, that could, trigger some of those principles that Joel was talking about when it comes to being a danger to themselves or others in the workplace, that you can't accommodate them if they're not going to be engaging in any treatment, because the prognosis then might be that they're not going to be improving. They might not actually be able to perform the key duties of their role. So again, the foundation here is make sure that you get that information about the limitations and the prognosis. What does it actually mean that they're not going to be accessing treatment and that this isn't what's going to be happening? And then once you have that information, I would say, seek advice from whoever it is that provides you advice in these matters, to make sure that you're covering off any additional loopholes as you decide what you want to do with that employment relationship.
Right. I'm going to tackle this next one, although I think this again relates to requesting medical information, but I want to turn as well.
Fair enough.
So we have a question. We have employees resistant to provide information, and they tell us, "Do not bother us while they're on leave." But if we need additional information, what's our recourse? And this goes back to the situation that I was talking about involving employees on WSIB or disability leave. Often employers are concerned that you may find an employee who really feels like they're being treated unfairly, or you're bugging them when they're on this leave. And that's exactly the situation that you're dealing with here. In that situation, it depends on what information you require, but in general, going back to what Alex talked about, this is a two-way street, and the employee does have an obligation to participate in the accommodation process. And where there's a legitimate need for their cooperation and information from them, even though they're on a leave, in order for you to manage your accommodation process, in order for you to determine what you're going to do operationally. Perhaps that's a common one. You need to know when the employee might come back in order to determine what to do with the open role. Then you can insist on that information, and if the employee continues to resist, ultimately you may be able to look at discipline pursuant to your policies, or determining that the employee, if they completely ignore you, that you may be able to assert that they've abandoned their employment at the end of the day. There are a number of steps to get there, where you need to make sure you're giving the employee clear warnings and expectations of what you need and why, but ultimately you may be able to get to a path like that. So we do have a question. This is just a general one, and I'm going to just tackle this one as we're getting to time, but we can stay on for a couple of extra minutes to tackle a couple of extra questions as well. And so there's a question about whether we'll be able to access the recording, and we will provide the recording to all the registrants to the webinar after the webinar. So Alex, I think this is one that you covered, but an important one to come up with, because I know it's hot on the press right now. With the most recent Working for Workers Act, will the potential inability to ask for doctor's notes impact requesting medical information?
The question is a great question, and the answer starts with the traditional lawyer answer of it depends. It depends on the nature of the circumstance. In this particular situation in Ontario, it may be the case that if there is a very short-term absence, the employee is away for a day, something like that, says, I need a sick day. or they're asking for a sick leave, related to an entitlement they have under the Employment Standards Act, which is just, they're not that long and not usually what we're talking about when it comes to disability management and the more complicated processes, that you may not be able to ask for a doctor's note in those cases. And the practical reality is that in most cases, employers don't do that anyway, absent a broader, attendance management piece that includes potentially some disability management that's been going on. So in terms of what we're talking about when it comes to a need for accommodation, need for disability management, likely that's not going to impact your ability to actually ask for the type of information that we're suggesting. But again, this would be a case-by-case assessment that I would recommend you address with the specific circumstances.
Right. And just before we take a couple of last questions, I just want to say thank you to those of you who aren't able to stay on any longer. I truly appreciate you spending an hour and a half with us here, and we hope you took away some really great information with you. And I hope to see you in a few weeks at our next webinar. And so with that, like I said, we'll tackle just a couple more questions before we wrap up here. And there's a really great question that came in just a couple of minutes ago that I'm going to tackle. And Alex, please jump in with anything you have to add. And so the question here is, if medical information was supplied multiple times by an employee, and it's determined based on that medical information that other accommodations are feasible aside from work from home, sounds like this is one of those situations that Alex talked about where the employee is saying, I want work from home and only want work from home. Is there a limit on the procedural obligation by the employer regarding requesting medical documentation? Really great question. And I would say, in general, yes, where you've obtained the information that you require as an employer and you believe that you have enough of an understanding to know what accommodations are reasonable in the circumstances, and you've made an offer of a reasonable accommodation to an employee and they are refusing that offer, that typically will be a position where you can say, I've fulfilled my procedural accommodation duty. I've now also fulfilled my substantive accommodation duty. I've offered the accommodation that's reasonable in the circumstances that works. Now, legally, that may well put you in a really good position. You want to consider practically in situations like that where employees are basically told take it or leave it. You may be facing a situation where the employee may be prepared to bring a claim. They may assert discrimination at that point. They may assert constructive dismissal. That's a type of situation where certainly I would encourage getting some advice if there's someone that you're able to get some advice from to determine those next steps and ensure that you truly have made a reasonable accommodation offer and you really have fulfilled that procedural accommodation duty. But certainly where it's determined that that's really the case, yeah, you don't need to keep on asking more and going through the process when you're confident that you have the information you require. And last question, I'm going to send this one back your way, Alex, to bring us home. What if the restrictions and limitations, I'm assuming we're talking here about the limitations that are set out on the medical note that the employee provided from their doctor, what if the restrictions and limitations were reported by the employee as opposed to observed by the physician through testing? And this is a good question because it's one we deal with all the time. Alex, what do you think?
Absolutely. It depends what you mean by reported by the employee. Is it things that are reported by the employee to the employer? Then, as we said, when it comes to requesting medical information, you don't take the employee's word for it. You go back to somebody who has the expertise to provide you with actual medical limitations, and you make sure you're asking the questions that you need in a sufficiently specific way and giving the doctor the information they need in order to provide you with that advice. Now, what if the employee is just telling the doctor, this is what my limitations are, and the doctor hasn't actually independently verified, they're just taking the employee's word for it? That can be quite challenging to deal with. And it's not something that typically employers actually really get to ascertain or really get to push back on unless a matter really escalates in some way, shape, or form. And because Joel, you let me talk, I'm going to take 30 seconds to give you a specific example where we had a situation like this arise as we were assisting an employer. In this case, the employee had made a claim for short-term disability benefits. The disability benefits were denied. The employee then commenced a legal action with respect to both the insurer and the employer. And in the course of this, the employee's counsel actually provided significant medical documentation, including the physician's notes, where they basically said, well, the employee said that they needed time off. It turned out that every interaction with the doctor was over the phone. The doctor never examined this employee. And we took the position that this meant that the information couldn't be relied on, and that it wasn't sufficient in order to support what the employee was actually asking for, because how does the doctor know? So there are arbitral decisions on this matter as well, where they challenge the validity of the medical information. But it is a reality that it's something that's very challenging for employers to deal with, because increasingly doctors are saying, yeah, okay, well, the employee told me this is what they need, this is what they need. Again, it goes back to making sure that you're asking the right questions that don't allow for that kind of flexibility for the doctor to give you a vague answer based on what the employee wants. You need specifics when it comes to limitations and prognosis.
All right, thank you, Alex. And like I said, that's going to bring us to the end of the webinar this afternoon. Thank you to all of you again for joining us. We wish you all the best as you lap up these last few days of beautiful summer. Thanks, everyone.